Hello, everyone, and welcome to Uncivil Law. I hope you're having a great day. And today is a classic. It is a classic from the past, 1999 decision. Can you buy a Harrier jump jet from Pepsi using Pepsi points? Yes, Pepsi had a promotion where if you bought Pepsi, they give you Pepsi points, and you could trade those Pepsi points in for things. And they had a commercial that said you could buy a Harrier jump jet for Pepsi points. And someone tried. And then someone sued because they didn't get their jet. This is a classic. It is the case of Leonard versus PepsiCo. Does PepsiCo have to give you a Harrier jump jet? Let's find out. Because whether a television commercial constitutes an offer is a central question in this case, the court will describe the commercial in detail. The commercial opens up in an idyllic suburban morning where the chirping of birds in sun-dappled trees welcomes a paperboy on his morning route. As the newspaper hits the stoop of a conventional two-story house, the tattoo of a military drum introduces the subtitle, Monday, 7:53 a.m. The stirring strains of a martial air mark the appearance of a well-coiffed teenager preparing for school, dressed in a shirt emblazoned with the Pepsi logo, a red, white, and blue ball. While a teenager confidently preens, the military drummel again sounds as the subtitle, T-shirt, Pepsi, 75 points, scrolls across the screen. Bursting from his room, the teenager strides down the hallway wearing a leather jacket. The drum roll sounds again as the subtitle, leather jacket, 1,450 Pepsi points appears. The teenager opens the door of his house and, unfazed by the glare of the early morning sunshine, puts on a pair of sunglasses. The drum roll then accompanies the subtitle, Shades, 175 Pepsi points. A voice then intones, introducing the new Pepsi Stuff catalog as the camera focuses on the cover of the catalog. The scene then shifts to three young boys sitting in front of a high school building. The boy in the middle is intent on his Pepsi Stuff catalog, while the boys on either side are drinking Pepsi. The three boys gaze in awe as an object rushes overhead. As a military march builds to a crescendo, the Harrier jet is not yet visible, but the observer senses the presence of a mighty plane. As the extreme winds generated by this flight create a paper maelstrom in a class devoted to an otherwise dull physics lesson, finally, the Harrier jet swings into view and lands by the side of the school building next to a bicycle rack. Several schools students run for cover, and the velocity of the wind strips one hapless faculty member down to his underwear. While a faculty member is being deprived of his dignity, the voiceover announces, now the more Pepsi you drink, the more great stuff you're going to get. The teenager opens the cockpit of the fighter and can be seen, helmetless, holding a Pepsi. Looking very pleased with himself, the teenager exclaims, sure beats the boss, and chortles. The military drum roll signs the final time as the words appear, Harrier fighter, 7 million Pepsi points. A few seconds later, the commercial appears with a more stylized script, drink Pepsi, get stuff. With this message, the music of the commercial ends with a triumph flourish. So yes, Pepsi had a rewards catalog, and they would give you stuff, including sunglasses and a leather jacket and purportedly a plane. Specifically one Harrier jump jet for the low price of 7 million Pepsi points. And Pepsi probably thought themselves, no one would ever take us up on that offer, but of course, then we would have this lawsuit. So of course someone did. So someone tried to buy the plane for 7 million Pepsi points. Let's read on. Inspired by the commercial, the plaintiff set out to obtain his deserved jet. The plaintiff explains that he's typical of the Pepsi generation. Sure, he's young, has an adventurous spirit, and the notion of obtaining a Harrier jump jet appealed to him enormously. Well, it appeals to us all, my friend. It appeals to us all. The rear foldout of the pages of the catalog contain directions for redeeming these Pepsi points. The directions note that merchandise may be ordered only with the original order form. The catalog notes that in the event a consumer lacks enough Pepsi points, and this is where things get interesting, so pay attention. The catalog notes that in the event the consumer lacks enough Pepsi points to obtain the desired item, additional Pepsi points may be purchased for 10 cents each. You can see exactly where this is going, right? However, at least 15 original Pepsi points must be obtained and accompanied with the order. So Pepsi would allow you to trade in Pepsi points, but that's okay. They'll let you buy more Pepsi points. So as long as you have 15, and you get Pepsi points from buying Pepsi products. I forget how many points there are, but it's probably like a point per a bottle or something. So you'd have to buy 7 million cans of Pepsi, or alternatively, give them money. So you can see exactly where this is going. Outstanding. Although the plaintiff initially set out to collect his 7 million points, good luck, it soon became clear to him that he'd not be able to buy, let alone drink enough Pepsi to collect the needed Pepsi points fast enough. Reevaluating his strategy, the plaintiff focused on the first time for the packing materials in the Pepsi Stuff promotion and realized that buying it would be a more promising option. Through acquaintances, plaintiff ultimately raised about $700,000. So somehow the hero of our story convinced friends in 1999, well, this case is 1999, so more like 1997, he somehow convinced his friends to fork over $700,000 of money. Where do I get friends like this? If you'd like a Harrier jump jet, please super chat to me, $700,000. I'd like friends too. Yeah. So, yeah, good times. On or about March the 27th, 1996, so I was pretty close. On or about March the 27th, 1996, the plaintiff submitted an order form, 15 original points, and a check for $700,008.50. At the bottom of the order form, plaintiff wrote in 1 Harrier jet in the item and 7 million in the total points column. In the letter accompanying the submission, plaintiff stated the check was to purchase additional points expressly for obtaining the new Harrier jet as advertised in your Pepsi Stuff commercial. He is our hero. He's not the hero we need, but he's definitely the hero we deserve. On or about May the 7th, 1996, defendant Fulfillment House rejected the submission and returned the check. Aww. He said no. So the people Pepsi hired to do this said no. And here's what the people Pepsi hired wrote. The item you've requested is not part of our Pepsi Stuff collection. It is not included in the catalog or on the order form, and only catalog merchandise may be redeemed under the program. The Harrier jet in the Pepsi commercial is fanciful and simply included to create a humorous and entertaining ad. We apologize for a misunderstanding or confusion you've experienced, and here's some free product compounds for your use. So the Fulfillment House said, no, but here's some stuff. Please go away. Did he go away? No, because then we wouldn't have this delicious, wonderful lawsuit. This is so great. Yeah. The outcome of this was written before it ever started. So I'm not sure what the random plaintiffs' attorneys were thinking, but they're probably thinking to themselves, sure, give us some money and we'll do this for you. Why not? That sounds good. The plaintiff's counsel responded on May the 14th, 1996 as follows. Your letter of May the 7th is totally unacceptable. We've reviewed the videotape of the Pepsi Stuff commercial, and it clearly offers a new Harrier jet for 7 million points. Well, technically speaking, it didn't say new. So there's that. Our clients follow your rules explicitly. This is a formal demand you honor your commitment and make immediate arrangements to transfer the Harrier jet to our client. If we do not receive a new transfer instructions within 10 business days, you'll leave us no chance to file action. I want my elephant. I want my elephant.
Where's my elephant?
Will Bart get his elephant? Who knows? This letter was apparently sent onward to the advertising company responsible for the actual ad, BBDO in New York, who are saying themselves, what the hell is this? In a later date, May the 30th, the vice president, Raymond McGovern, said to the plaintiff, I find it hard to believe you're of the opinion the Pepsi Stuff commercial really offers a new Harrier jet. The use of the jet was clearly a joke that was meant in the commercial to be more humorous and entertaining. In my opinion, no reasonable person would agree with your analysis of the commercial. Yeah, but then again, I guess members of the Pepsi generation are not reasonable people. So query whether we have to modify the reasonable man test. Are reasonable men definitionally not part of the Pepsi generation? These are the questions that are raised by this case. Outstanding. On a motion for summary judgment, a court cannot try issues of fact. It can only determine whether there are issues to be tried. To prevail on a motion for summary judgment, the moving party must show there are no genuine issues of facts to be tried, and they're entitled to a matter of judgment. Yeah, there are no issues of fact here. We know what the facts are. Guy sent in a check for $780.50 and 15 Pepsi points and wants his Harrier jet. Not a lot of facts in dispute. So yeah, we don't need a jury. We just need to figure out what is the law. The law is not that you get a jet. I mean, no, just no. The question of whether a contract is formed is an appropriate resolution for summary judgment. Yeah. As the Second Circuit has noted, summary judgment is proper when words or actions that are alleged are so clear that reasonable people could not differ over their meaning. The key word in that sentence being reasonable. Reasonable people. Reasonable people could not differ over their meaning. Members of the Pepsi generation are apparently not reasonable, I guess. So you might want to know if, in general, an ad is an offer in terms of contract, right? So for contract, you need offer and acceptance. Yeah, you need an offer and acceptance. So you might want to know, is an ad an offer? In other words, can you accept an ad? Is it the offer that you can accept? The answer generally is no. Ads are, generally speaking, not offers. They are invitations to treat. Ooh, all the lawyers in the room go, ooh, because I know what that means, yes. But let's read a little bit from the restatements. The general rule is an advertisement does not constitute an offer. The restatement of contracts explains that advertisements of a good by display, sign, handbill, newspaper, radio, or television are not ordinarily intended or understood as offers to sell. The same is true of catalogs, price lists, and circulars, even though the terms of suggested bargains may be stated in some detail. It is, of course, possible to make an offer by advertisement directed to the general public, but there ordinarily must be some language of commitment or some invitation to take further action without communication. Similarly, a leading treatise notes that it's quite possible to make a definite and operative offer to buy or sell goods by advertisement in newspaper, by handbill, or catalog or circular, or on a placard at a store. It is not customary to do this, however, and the presumption is the other way. So normally, an ad or a sign on a store is not technically an offer. So I know this will make all the Karens of the world very, very sad. But technically speaking, when you go into a store and it has a price on the shelf, and they scan it and it has a different price, you can't say, oh, it was advertised to me, you have to sell to me for this price. Technically, no. Technically, no. Technically, it's considered an invitation to treat. So when you go into a store and you go to a shelf and it has a price on the label and it says so much, and you go and they say, it'll be this much. You can't say, but it was offered to me. Technically, no. It wasn't offered. There was an invitation to treat. So technically, when you come to the register and you give them the thing to ring up, that is the offer. You're making the offer, not the person who is selling it to you. So I know it's a little weird, but we have this in law. So when you go to a store and you try to buy something, you're the one making the offer, not the person who's selling it. The law is pretty clear on this. So if they give it to you for a discount price, it's because they feel like it. Technically, it is not considered an offer. So there you go. So no, if they give you a discount, it's just because they felt nice that day. In opposing the present motion, the plaintiff largely relies on a different species of unilateral offer. So this would be the exception to the rule, when there's a unilateral offer. And by the way, incidentally, to accept a unilateral offer is only by performance. You can't say, I will do it. You must actually do it. But yes, so let's look at unilateral offers involving public officers for a reward for performance of a specific act. So yeah, your classic unilateral offer, and not all states recognize unilateral offers, incidentally, but your classic unilateral offer is a sign on a lamppost that says lost dog, reward, $500. That'd be considered a unilateral offer. And it is the only way to accept is by performance. So you show up with the dog, and then you can ask for the money. And not all states recognize it, so your states may vary. But that's your classic unilateral offer, acceptance by performance. Because these cases generally involve public declarations regarding the effectiveness or trustworthiness of specific products, normally like the dog in the example, very specific product, one court has aptly characterized these as a prove me wrong case, that too. The most venerable of the unilateral offer cases is a case called Carbolic Smoke Ball, which brings a warmness into every lawyer's heart. We all know Carbolic Smoke Ball. A quote from which the plaintiff memorandum of law: if a person chooses to make an extravagant promise, he probably does so because it pays him to make them. And then if he makes them, extravagance of the promise is no reason why it should not be bound. So now we need to learn about the wonderful case that is Carbolic Smoke Ball. Let's learn about this case. Long a staple of law school curriculum. Yes, we all read this one in law school. Carbolic Smoke Ball owns his fame not merely to the comic and slightly mysterious object involved, which is a smoke ball of a carbolic nature, but also because its role in developing the law of unilateral offers. The case arises out of the London influenza epidemic of the 1890s. This might be relevant to today, people, so keep attention. Yeah, if you're trying to offer products to cure COVID, this is relevant to you. Pay attention. Along other advertisements at the time, for Clark's world-famous blood mixture, towels, pennyroyal, and steel pills for females. What is a pennyroyal and a steel pill for female? Do any females in the room have any clue what a pennyroyal and a steel pill is? Do I want to know? Sequoia's prairie flower, whatever that might be, and Epps glycerin jubles appeared solicitations for the Carbolic Smoke Ball. Yes, good times. The specific advertisement that Miss Carlyle saw and relied upon is the following. Here's what the ad said. £100 reward will be paid by the Carbolic Smoke Ball Company. So the ad that Miss Carlyle saw read as followed. £100 reward will be paid by the Carbolic Smoke Ball Company to any person who contracts the increasing epidemic of influenza/COVID, colds, or any disease caused by taking cold after using this ball 3 times daily for 2 weeks, according to the printed directions supplied with each ball. £1,000 is deposited with the Alliance Bank, Regent Street, shewing our sincerity in the matter. During the latest epidemic of influenza, many thousands of Carbolic Smoke Balls were sold as preventatives against this disease, and in no ascertained case was the disease contracted by those using the Carbolic Smoke Ball. I feel reassured. That's for damn sure. On faith of this advertisement, Miss Carlyle purchased a smoke ball, used it as directed, but unfortunately contacted the COVID. Very sad. The advertisement was construed as an offer because it sought to include induced performance, unlike an invitation to negotiate, which we now call an invitation to treat, which seeks a reciprocal promise. As Lord Justice Lindley explained, advertisements offering rewards as offers to anybody who performs the conditions, and anybody who does performs accepts the offer. Because they had complied, she was owed the $100 or £100, which at the time I assume was a lot of money. In the present case, the Harrier Jet commercial did not direct anyone who had appeared at Pepsi headquarters with 7 million Pepsi points on the 4th of July would receive a Harrier Jet. Instead, the commercial urged consumers to accumulate the points and refer the catalog to determine how they could redeem them. The commercial sought a reciprocal promise expressed through the acceptance and compliance with the terms. As noted previously, the catalog contains no mention of the jet. Plaintiff states he noted the jet was not among the items described, but this does not affect his understanding, and it should have. In evaluating the commercial, the court must not consider the defendant's subjective intent in making the commercial, or the plaintiff's subjective view of what the commercial offered, but what an objectively reasonable person would have understood the commercial to convey. That would be nice. It is clear the offer is not serious. You don't say. Then no offer has been made. Quoting, what kind of act creates a power of acceptance and therefore an offer? It must be an expression of will or intent. It must be the act that the lead offeree reasonably conclude that power to create contract is conferred. This applies to the content as well as its existence. It's on this ground we must conclude invitations to deal are mere preliminary negotiation, and acts evidently done in jest do not create a legal relation. No joke. The plaintiff's insistence that the commercial appears to be a serious offer requires the court to explain why the commercial is funny. Explaining why a joke is funny is a daunting task. As the essayist E.B. White has remarked, humor can be dissected, as a frog can, but the thing dies in the process. Okay, this has got to be my favorite part of the opinion. All right, so the court is now going to explain the joke. So if you thought there was nothing better than someone trying to explain the joke, the court is now going to explain the joke. Outstanding. Let's explain the joke in laborious legal language. This is the greatest thing of all time. A joke explained in legal language. Outstanding. First, the commercial suggests, as commercials often do, the use of an advertised product will transform what, to most youth, can be fairly routine and ordinary. The military tattoo and stirring martial music, as well as the use of subtitles in a courier font, apparently it was courier, that scroll terse messages across the screen, such as Monday, 7:58 a.m., invoke a military and espionage thrillers. The implications of the commercial is that the Pepsi stuffed merchandise will inject drama and moment into hereto unexceptional lies. The commercials in this case thus make an exaggerated claim, similar of those in most television commercials, that by consuming featured clothing, car, beer, or potato chips, one will become attractive, stylish, desirable, and admired by all. A reasonable viewer would understand such advice as advertisements as mere puffery, not statements of fact. You know, I'm disappointed because I understood these commercials as a statement of fact, and I was looking forward to the riches, fame, women, prosperity, and all the rest that all these commercials promised me. Are you telling me that all these commercials have been lying to me? Man, that sucks. Second, the cowled youth featured in the commercial is a highly improbable pilot, one who could barely be trusted with the keys to his parents' car, much less deprived aircraft of the United States Marine Corps. Rather than checking the fuel gauges on his aircraft, bad flying, the teenager spends his precious pre-flight minutes preening. The youth's concern for his coiffure appears to extend to his flying without a helmet. Finally, the teenager's comment that flying the Harrier jet to school surely beats a bus evinces an improbable, insolent attitude towards relatively difficult and danger. Piloting a fighter plane is a residential area as opposed to taking public transportation. I do love it when the court explains the joke. That is the best thing of all. Third, the notion of traveling to school in a Harrier jet is an exaggerated adolescent fantasy. Damn it. In this commercial, the fantasy is underscored by how the teenager schoolmates gape in admiration, ignoring their physics lesson. I don't think that's that hard to believe. I'm pretty sure that a person letting a jump jet would take precedence over the physics. The force of wind generated by the Harrier jet blows in one of the teacher's clothes, literally defrocking an authority figure. As to emphasize the fantastic quality of the jet, arriving at school, the jet lands next to a plebeian, I say, bike rack. Not just any bike rack, plebeian bike rack. The fantasy, of course, is extremely unrealistic. No school would provide a landing space for a jump jet or condone the disruption. Yeah, if you're a jet that's capable of vertical takeoff and landing, I'm not sure you need to be provided a space, but whatever. Fourth, the primary mission of the Harrier jet, according to the Marine Corps, is to attack and destroy surface targets under day and night visual conditions. The jet is designed to carry considerable armament, including a Sidewinder and Maverick missiles. In light of the jet's well-documented function in attacking and destroying surface and air targets, armed reconnaissance and air interdiction, and offensive and defensive anti-aircraft warfare, depictions of such a jet as a way to get to school in the morning is clearly not serious, even if, as Planff contends, the jet is capable of being acquired in a form that eliminates its potential for military use. In sum, there are three reasons why Planff's demand cannot prevail as a matter of law, because it's stupid. First, the commercial was merely an advertisement, not unilateral offer. Second, the tongue-in-cheek attitude of the commercial will not cause a reasonable person to believe that the software company would be giving away fighter planes. And third, there's no writing sufficient to the statute of frauds. Not so sure about that last part, but I'm pretty sure, at least to my mind, the advertisement does satisfy the statute of frauds. The court disagrees with me there, but it really doesn't matter on the outcome. But whatever. For the reasons stated above, the court grants the motion for summary judgment. The clerk is instructed to close the case. Any pending motions are moot. So that is the end of the case of Leonard versus PepsiCo. In this case, Leonard himself decided to get a jump jet, but it was not to be. He tried to exchange $780.50 and 15 points for his jump jet, but he was denied. And he's denied by the court because the court says, really? Really? Seriously? Really? Seriously? Yeah, and it's like, no, you can't do that. You can't do this because it wasn't a real offer. It wasn't a real offer because, one, it's not an offer, period. And two, it's a joke. It's a joke. But he got a law firm to send the money in because I don't know why. But that is the end of the coverage of this case. Thank you so much for being part of the Uncivil Law family. I appreciate your continued support. If you haven't already done so, please subscribe to this channel, and you can also support us financially by clicking the applaud button below. Thank you so much for your contributions to our channel. It helps our work grow. Until later, cheers and goodbye.